project. I would like to start with the presentation of our project. Amalia, do you have to say something about this project? Yes.
Yes, just a little reminder. I would like to inform you that by taking part into this event, you accept to be video recorded, and we will publish the video recording of the workshop in the website of the project, as required by the grant agreement that we signed with the EU. And furthermore, we ask all the attendees to this event to fill in the feedback form that you will find attached in the chat of the event. We need your answers to this form, as also this task is required by the EU. But the representatives of the University of Catania and the representatives of the EU bodies should not fill in this form. For all the other attendees, please fill in carefully the feedback questionnaire. Many thanks.
Okay. So first of all, I would thank everybody for the participation in the project. Some of yours have also given the answer to our very rich questionnaire. So this has been a very precious collaboration for our project. So some word only in order to present the project. I will share with you a very brief presentation. Okay. So can you see?
Yes, we can.
Yes. Okay, perfect.
Yes, we can. We can see it.
So the title of our project, Strengthening the Protection of Youth Financial Interests via Criminal Law, a comprehensive study on fraud prevention, anti-corruption, and anti-money laundering measure and corporate crime. The research, the aim of the project is to contribute to the consolidation of the protection of the youth financial interests through a systematic analysis of the legislation, fraud, corruption, money laundering, and the liability of legal persons connected with this crime. Since an even implementation of due regulatory tools creates different level of protection of youth financial interests, so the investigation aims to assess the effectiveness and the level of implementation of some legal instruments, such as the PIF directive, the regulation of 1995, 2988, that is the fundamental instrument which give the use the principle of the administrative punity of the European Union administrative punitive powers.
Yo esa parte estoy con...
The new directive of 2024 on recovery and confiscation of assets, the new proposed directive on corruption, and the provision recently approved on anti-money laundering, and not only the EU regime about anti-money laundering. And additionally, we will analyze also the European Union legislation about the practices about the European Public Prosecutor Office in prosecuting PIF crimes. The research will try to analyze a comparative approach, examining the legislation of 8 member states: Italy, France, Spain, Germany, Poland, Romania, the Netherlands, Ireland. The remaining European Union member states will be involved during the international conference trying to maximize the research results and their broader dissemination. From a methodological standpoint, the research team will conduct a DEX analysis of relevant regulatory provisions, develop an assessment of their practical application by conducting interviews with experts and also through the questionnaire, and actively engage practitioners and stakeholders during the workshop and the conference. The ultimate goal of is the formulation of best practice from proposal and policy recommendation aimed at optimizing European policy on the protection of the financial interests and combating economic crime. So it will be very interesting to start also in this workshop, try to have in your presentation and in the moment of debate, try to focus about the some proposal in terms of best practice, reform proposal, and policy recommendation. In particular, the project consists of the following main steps. The first steps is in the first period of the first 6 months will be focused in order to assess the extent of implementation of key EU legal instruments in the realm of the protection of EU financial interests, with specific regard to the 8 member states which are involved in the project, particularly to analyze the implementation of both the PIF directive and the regulation 1995 on the EU administrative punitive power, to focus confiscation as an essential tool to protect EU financial interests in consideration of the regulation mutual recognition of 2018 and the new directive about confiscation and state recovery office, to focus the role of the EPO in prosecuting the PIF crimes, and to delve into the main interpretative issue with concern the regulation 1939 of 2017. The second step, the second phase of our project is focused on EU legal tools to combat corruption involving harm to the EU financial interests. In particular, we will try to evaluate the implementation.
Malgeri, I'm sorry for interrupting you, but we cannot see the change of the slides at this moment.
Oh, okay. So I can try to. Now?
No.
No. So what can I do is interrupted the presentation?
Yes, yes.
Yes, but I need. Okay, a moment. I will try again to share. Okay, where is? Sorry, only a moment. See here. So. So I don't know which is the problem, but I am not more able to share. Okay, so I continue also without the slide. It is not a problem. So the second step is the evaluation and the implementation of EU legal instrument aimed at combating corruption, always in the 8 member states, to face crucial issues such as the scope of the definition of a public official and the difficulties in drawing a clear separation between public and private areas, in applying bribery offense and corruption-related offense, to analyze the strengths and the weakness of the new proposal for a directive on combating corruption, to identify and assess the anti-corruption measures to be eventually adopted on the basis of the above mentioned proposal in the selected member states. The third step, the third phase of our project is focused on anti-money laundering and the protection of EU financial interests. So an analysis, we will try to realize an analysis of the existing anti-money laundering legislation at the EU level and its implementation in the 8 member states, to delve into know your customer practice, to analyze the crucial issues such as the compliance with the nebis-in-idem principle with regard to the offense of self-laundering and the challenges raised by new technologies, especially crypto assets, about the respect of anti-money laundering laws. To analyze the role of organized crime in the commission of a PIF offense, and to delve into the EU legislation against organized crime, in particular the framework decision 841 of 2008. The fourth step of our project will focus on evaluation of corporate liability frameworks in connection with this crime. So is aimed to evaluate the legal frameworks governing corporate liability for fraud, corruption, and money laundering, both at the EU and at national level, with particular regard to 8 member states. To focus the role of complex programs as an essential instrument to protect EU financial interests, to analyze the role of freezing and confiscation orders issued against corporations with the aim to combat fraud, corruption, and money laundering, and to detect other crucial issues, such as the matter of the pre-trial agreements between prosecutors and corporations. The fifth step of our project is aimed to contribute to the debate by elaborating interpretative guidelines for practitioners, reform proposal, both at the national and EU level, policy recommendation, best practice, to promote mutual learning among all member states on the project's results, to build awareness and support for the project and its objectives among key stakeholders, for example, National Bar Association, Ministries of Justice, Apple National Office, to disseminate the project's results in the policy, scientific, and wider stakeholder community. The 2-year project will produce the following deliverables: scientific publication on the project's context. This is one of the main goals, scope of this project. Interpretative guidelines, reform proposal, and policy recommendation to be collected in a devoted database. Specific online workshop with experts for the 8 member states which are involved in the comparative analysis. An international seminar at the end of the first year in Catania with the involvement of stakeholders from all over the EU member states in February, the next February. An international conference at the end of the project, a comprehensive handbook encompassing all the main project results. Okay, in the end, in 2 slides, I would like to share the title of the articles which of the publication, scientific publication to be produced throughout the project. I suppose that is not so interesting to add these different titles, but in any case, at the end of the end of our workshop, I will share this presentation, so you have the possibility to read the different title of the scientific publication which we would like to produce during our project. So, there are any question, doubts? Other way, I will carry on with our project, and I give the floor to Professor Sicurella, Professor of Criminal Law in the University of Catania, for the presentation of the main topics of the second work package and the related research outputs. The second package is about the assessment of EU legal instruments for protecting financial interests, focus on selected member states and EPO material competence. Rosaria, I give you the floor, and thank you.
Yes,
for your...
thank you, Anna Maria, and really good morning to everybody. I must say I'm really happy to see you at least on the screen, and I think I will look forward to meet you. I hope in person on February and other occasions of the project. Anna Maria presented all I would say, the objectives, the overall objectives of the project. I will try now to focus on the topics of the second work package and obviously the outputs of this first stage of the research. But first of all, I wish to start, I think, with setting the scene of our study, of our project. So, since directive dates now back, few years. The delay to transpose the directive was adopted, we all know, in 2017. The delay, the time limit for the transposition, the implementation was 2019. So now in 2025, focusing on the assessment of the new legal instrument in the PIF sector. Indeed, this is a very crucial moment concerning various areas of EU legal order or organization, and so also for the PIF, for the protection of EU financial interests. Indeed, the protection of EU financial interests faces at the moment significant challenges, because we are living in an increasingly complex and rapidly evolving landscape. We all know that rapid developments in technology, financial systems, and global crime networks occurred, and this requires the EU and also the member state to adapt very swiftly to emerging threats. This is not a case that in the last, more or less the last two annual reports, the PIF reports that the Commission is required to draft according to Article 325. One of the main point was digitalization of all, I would say, actions and all means to counteract fraud or offenses against EU financial interest. Having said that, very recently, on the 16th of July 2025, the Commission has adopted a communication on a white paper concerning, a review of the overall fraud architecture. This means that it is now ongoing a structured reflection process to review the overall EU anti-fraud architecture. That means the institutional side and the, I would say, the legal side, with the common objective to better address challenges and bridge existing gaps in the protection of the EU financial interest. And this review was extremely necessary. It's a critical moment, I was stressed before, because transnational fraud schemes are becoming more sophisticated. Organized crime continues to target EU funds, and also criminal networks increasingly exploit advanced technologies such as the artificial intelligence and also cryptocurrencies to misappropriate EU funds. And obviously, this review process is conceived as an opportunity to improve and streamline cooperation between the various actors, drawing on the outcomes of relevant ongoing evaluations of the legal frameworks applicable to certain actors relevant to the anti-fraud architecture, such as Eurojust, Europol, OLAF, obviously, and the NDF. And what is important, and now I come to our, project somehow, the member states are also deeply involved in this process. We all know that the member states share the responsibility for protecting the EU financial interests and fighting fraud. More than that, member state authorities manage more than 85% of EU expenditure, and those authorities collect the EU's traditional own reserves. In its last, I would say, annual PIF report, the 2024, that was published on last July 25, referring to the previous year, the Commission reiterates the recommendation to the member state to adopt a national anti-fraud strategy in the sense of a formal document to protect EU financial interests, which is considered by the Commission as a key element of the overall anti-fraud governance in the EU area. And these strategies, in the view of the Commission, can ensure that the various national actors involved in the PIF take a common approach, and this can facilitate cooperation also with the EU level. The complexity of transnational investigation, particularly in tracking financial frauds, underscores the importance of a strong cooperation between the EU and national actors in the anti-fraud architecture. And their role appears even more pivotal with the progressive adoption of national plans, for example, concerning the national recovery and resilience plans or the national agriculture plans underpinning the spending of EU financial reserves. And the adoption of such a national strategy that involves, I stress again, also, proposal for legal reforms is one of the main recommendations of the last annual report, recommendation number 3. And what is interesting is that according to the provision that were provided by the member states to the Commission in the previous year, 21 out of the 27 member states indicated that they have this anti-fraud strategy in place. However, when looking at the strategy that we're talking about, actually the situation, the approach was extremely heterogeneous, where only actually 10 countries out of the 27 had adopted a proper, I would say, national anti-fraud strategies, and the others, they were just referring to other type of strategy that were sector not specified anti-fraud strategies, like it was requested by the Commission. So against these backgrounds, examining the main legal text dealing with PIF protection is highly relevant. I will just remind the key topics of work package 2, but the focus of this workshop, because actually, as also Professor Mangieri stressed, there is not a perfect overlaps in the sense that topics of work package 2 were, more extended with respect to what we are going now to, to discuss today. The focus of the workshop would be essentially assessing the implementation of the PIF directive, so Direct 2017-1371, in the 8 national legal orders that were selected for the project, as Professor Maggiore was mentioning: Italy, France, Spain, Germany, Poland, Romania, the Netherlands, and Ireland. And we will focus in this workshop essentially on implementation, on national implementation, on national level of Article 3 of the PIF directive. If you look at the program, you will see also that there are also few contributions concerning the implementation of the definition and the minimum rules on corruption, so Article 4 of the directive. Although the topic of corruption is integrated in Work Pattern 3, so again, it will mostly be dealt with during the annual conference. And Work Pattern 2 also dealt with the implementation of Directive 2024/1260 on asset recovery and confiscation, and the enforcement also of regulation on mutual recognition of freezing and confiscation orders, that again will be essentially discussed not in this workshop, but in the annual conference. So the main legal test, Directive Article 3, PIF Directive Article 3, and then the other main, I would say, legal test that will be focused in this workshop is Regulation number 2090/88 of this 1995. Which is the regulation concerning non-punitive sanctions that was conceived as a general regulation concerning administrative sanctions, not at EU level, but at national level when implementing EU legislation. So this means that considering the questions in the question put in the questionnaire, we are trying to we will discuss also about effectiveness of the enforcement at the national level of non-criminal or administrative punitive measures adopted at national level or any way employed to counteract fraud against EU financial interest. And this also in respect to the interactions with criminal or other enforcement regime at national level, especially with respect to possible problematic compliance with the principle of ne bis in idem. And then there will be also some contribution trying to focus also on the consequences of the present legal framework on the functioning of the EPPO, that we know that essentially the main competence of the EPPO essentially rely on the, I would say, the national implementation of the PIF directive. I had a look to the questionnaires, and for sure, this will be this. I would like to stress some interesting trends emerging from the questionnaire, and also in this way, I hope to also raise some, to put some inputs for the discussion during this workshop. First, I think the one of the things that really is really striking, and when looking at the answers given in almost all the questionnaire, the first question, or the answer to the first question concerning the overall assessment about implementation of the PIF directive, I would say that in line with what resulted when the Commission drafted its first report on the implementation of the PIF directive, is that all the national reports mostly confirm that directive's core provisions have been transposed. There are, in some reports, there are even, a very, I would say, some of the reports really stress in a very, say, emphatic and even optimistic way the full compliance of their national system with the directive. And this is, for example, for some of the countries having gone through the, I would say, the infringement procedure, the wishes to stress that they now comply with obligation in the directive. I think it's interesting to to highlight, because this could be interesting also to discuss in this workshop, of the list to discuss in line, the view of the final publication of the outcomes of this project, that I saw that a partially different answer has been provided to this question by sometimes the academic on the one side and the practitioner on the other side, representing the same legal systems. I realized that this happened concerning the satisfactory or non-satisfactory implementation process in their legal system. As often, or maybe always, happens, the academic view is less optimistic. So normally is in the academic report that we find more criticalities. This is the case for France, and above all, I think, the difference, at least in the way the report was drafted. This was the case especially for Poland, because only, in the report by the academic, the reference is made to a very recent notice issued on, the 1st June 2023 by the Commission concerning the introduction of an infringement procedure. That is, this means that still in 2023, the Commission raised, there were several conformity issues regarding the definition of some criminal offense and the related criminal penalties, and also issues concerning the liability of legal persons for crimes committed for their benefit. And also only in this report I found also the indication, the information about proposal for legislative changes that are still waiting to be put on the agenda of the Parliament. Apart from that, I would say that looking again to the answer of the questioners, we can conclude in the sense that in the largest majority of the member states, I would say, when I refer now to the member states, I refer to the 8 member states involved in the, in the project, the national legislator has not engaged in a radical reform of the pre-existing legal framework. This is clearly indicating in the report, from Italy, France, also the Netherlands. What this means that, generally speaking, member states considered that their system largely complies with the obligation in the directive, and this essentially because most, say, of the PIF directive provisions, the sense of the description, definitions in the PIF directive, often overlap with those in the 1995 PIF Convention that, as a matter of principle, was transposed by all the member state, and there is obviously some of the member states participate to the project, and I refer essentially to Poland, Romania, in different stage, stressed that they indeed had engaged in a large reform, but when they were during, I'd say, the process of their accession to the European Union, when they were asked to adapt their national legislation to the PIF Convention requirements.
Sentiamo.
Aspetta.
Actually, I heard Professor Sigurella.
The macro is on. I don't know why.
Yes.
Yeah?
No,
Okay.
I think that Professor
Okay.
Anna, mi senti? Is it fine?
Yeah. Yes, I think
No
so.
more?
No, I think that Professor Maggiari has problems with her microphone.
Okay. Sorry.
I think it's, the micro is on at the moment.
Yes.
Okay, now?
We can hear. Yes,
Okay.
yes.
So, having said that, what we see is that, looking at the, at the presentation, at the reports, at the national report, we could see that after the entry into force of the directive, there were generally speaking, there were a very limited number of new offenses that were introduced at national level, or even slight modification of previous wording in order to comply with obligation in the directive. And what is also can be stressed that very often amendments were often limited to the sanctioning aspect through a tightening of existing sanctions. It is interesting to, here in my presentation, I really quoted like a paragraph of that I taken from the the Dutch report and the French report by, Araceli Turmo, where it was clearly indicated that at the very beginning of the debate concerning national legislation to be adopted to implement the directive, the approach was more ambitious. So with I would say an extensive approach to the modification, to the amendment to be realized at national level. But then, in both situations, for example, the Dutch report stressed that at the end of the time, the final outcome was a small amendment, again, raising the penalty level on the fraud offense, that was then followed by a smaller amendment of the implementing legislation after a notice by the European Commission on the really slight problem of implementation. So the Dutch legislation was somehow incomplete on some points. And also a different remark maybe can be done concerning the situation in France. At the very beginning, there were several provisions that were worded making a specific references to offenses affect the protection of your financial interests. But then there was a later reform in 2020, removed this, I would say, specific reference to the European, fraud, but maintaining the higher sanctions. So this means that there was an overall tightening of the sanction in the area affected by I would say, the scope, by the offenses in the directive. So for what I understood, this can be again a question to be debated, is probably what happened in France is what we call an harmonisation en cascade. That means that something that sometimes is very criticized at the national level, that whenever there is a change concerning a specific EU interest, then this can induce I would say a more extended process in all offenses or areas, or at least topics that are not directly affected by the EU legislation, but anyway, they are connected to it. Differently, in Romania, in the report, I think is maybe the only country that has devoted a specific section of the criminal code to crimes against the financial interests of the EU. Some amendments were also adopted following the formal notice from the Commission of the launching an infringement procedure. For what I understood, following that, at present, Romania appears to comply with the PIF directive provisions. I put a question mark just again to be, confirmed, discussed in the, the debate. Against this, I would say, quite optimistic approach expressed concerning the overall implementation of the directive, we must stress, first of all, that even in countries, for example, Italy, that objectively where the criminal code already provided the main, I would say, offenses to implement, actually to comply with the directive. However, a more comprehensive approach would have been desirable, aiming at guaranteeing the overall coherence of the system of offenses and sanctions in that area. In addition to that, when looking against this, I would say, optimistic, again, initial assessment, but when looking at the specific questions, it can be noted that certain gaps and shortcomings in national implementation remain that obviously can affect the directive's uniform application, the safeguarding of EU financial interests, and the proper functioning of the EPPO. I selected, I would say, few issues to be, that could be discussed today, but obviously just because I did not have the time to discuss about everything. For example, implementation of Article 3 of the PIF directive. Article 3, we all know, is this very long, complex, articulated provision dealing with all forms of frauds, revenue and expenditure fraud, non-procurement related fraud, procurement related fraud, non-TVR fraud, TVR fraud. And that means that we are dealing with really the core provision probably of the directive, which is, I mean, interesting to stress, is that we still have some problems. I mean, in the legal orders that we have examined in the project. I wish to, I mean, stress the situation in Poland. Obviously, I really wish to stress we are not here to judge, but just to understand exactly which is how the situation is. It seems, and again, I took this information from the report of the academic. Poland still faces quite significant transposition challenges, essentially with respect to forms of misappropriation of EU funds or asset. And this actually is it was indicated in, the same gaps were indicated by the Commission in the notice that the Commission put, as I told, in 2023. The provisions, that to be short, the provision that I mentioned are different, provision in Article 3 deals essentially with forms of misappropriation of EU funds or assets, depending, in non-procurement related expenditure, procurement related expenditure, frauds related to revenues, ordinance TVR, and also frauds related to revenues to the TVR. And also the Commission also indicated other provision in Article 3. Again, concerning another very crucial point of the definition in Article 3, which is the fraud related to public procurement. There, in some legal orders, clear that specific offenses are still missing. In the report that was drafted by experts from France, it's interesting that they stress that since 1991 there is a specific offense dealing with fraud related to public procurement, which is the délit de favoritisme. But the thing is that this offense can be realized just by specific, I would say, by qualified authors, that is to say, essentially person holding public authority or entrusted with a public service mission or holding elective public office or other forms anyway of particular, specific positions. This means that in general, so when there is not such a qualification of the author, there is no, I would say, general offense concerning fraud by a private, I would say, by a normal individual related to public procurement. And with respect also to the issue that was mentioned in the questionnaire of measures that can be adopted other than criminal sanction. For example, it's interesting, I wanted to mention what was said in the report from Germany, just because it's something that can also appear in other topics and any other issues because of the, I would say, constitutional organization of Germany, because according to the report, while federal law and essentially the Competition Act provides for grounds for exclusion from contact award, there are following several criminal offenses, including fraud and corruption offenses, so the offenses that were considered by that directive. Then there is also each individual federal state that adds its own set of rules, so the situation will be not always very clear. Looking at another crucial provision of the directive is, I would say, a provision of the general part, so the obligation to punish also the attempt and the participation to the offense, which is provided for in Article 5 of the Fifth Directive. Here the situation is quite different, because as for the participation to the offense, for what I understood looking at the reports, no one, let's say, stated or affirms that there were this was problematic. Generally speaking, there is a general provision in the criminal code which is applicable to all the offenses, and so because of that, it will be applicable also for, for offenses eventually, introduced to implement the directive. On the contrary, criticalities raised concerning the implementation of the attempt. Because again, in most of the reports for attendance, in most of the legal system, again, attempt, refers to a general, the provision of the general part. There are some member states where the punishment with the criminal relevance of the attempt is specified in the provision dealing with this, with a specific offense. But what is interesting is that most of the legal orders, they, before the directive, they did not punish some, they did not punish attempt in some of the offenses dealt with in the directive. So the member state essentially had to modify their legislation about punishment of the attempt. For example, this was even the case in Italy concerning VAT frauds. Was the case, for example, but it's just examples again. In France, for the offense of abus de confiance and the tournement de fonds publics. And we must state that this, I would say, modification, these amendments actually raised some criticism, at national level, because, they somehow contrast with the discretionality, with the decision, I would say, of criminal strategy, criminal policy by the national authority concerning relevance, of the attempt. And there's another point which does not really, matter in this workshop because it deals with corruption. That sometimes the problem to punish the attempt in corruption offenses can create problems for those systems where corruption offense is already integrated with just the conduct of one of the two sides of corruption, so that whenever you ask for a payment, etc., you have already a completed, I would say, offense and not just, the attempt. The other focus, and go very quickly to the end, the other focus apart from the PIF directive, the other focus of the workshop is look at the administrative punitive protection of financial interests of the EU and essentially look at the enforcement of Regulation 2000/1988, which is still, the main point of reference. Looking at the questions, we see that still in 2025, most of the member states, there's not really a general system of punitive non-criminal sanctions, though punitive sanctions exist in some specific areas, for example, the fiscal one. The consequence of the non-existence of a general system is also, generally speaking, a limited attention to compliance with general principles in the regulation, so legality, culpability, proportionality. However, as was stressed in the report from Maracciali Turmo, proportionality principle, generally speaking, had an impact also on the implementation of administrative sanction, but not as a general principle of the regulation, but as a crucial general principle of EU law in general. And in some cases, and I was stressing this is especially the case in Germany, but also in Romania, the report stressed that these principles are binding from the national legislature independently of EU law because of their constitutional status, this is the case in German, or their relevance with respect to administrative sanctions dealing with protection already of the national budget. In some reports, they were clearly indicated that there are still criticalities about compliance. So where the two regimes exist for the same offenses, so administrative and criminal, there are criticalities very often about compliance with the Human Rights Court case law on the bis in idem in case involving double track enforcement. For example, France clearly says that this happened in fiscal matter. This is interesting to stress what is referred to in the Polish report by, the academic, where it is probably the only report where I could find that there was a direct reference to the regulation in the case in which, in a specific case, in a very important case where the Supreme Court submitted a question for a preliminary ruling to the Court of Justice. And in domestic cases also, some provisions, Article 134 of the regulation says is relatively often a point of reference in the case law of administrative court. Few words of conclusion. So what I could see in the report is that, generally speaking, all the member states involved in the project result to have implemented in the PIF directive. Divergence anyway appears in national implementation, and also unresolved gaps persist, and this clearly risks to undermine the uniform application and weaken also the level protection envisioned by the treaty. So this means that strengthening the Union's financial interest protection, which is one of the main objectives of our project, also in order to comply with the obligations stemming from the treaty, and also obviously secondary legislation, still require targeted legislative reforms and closer coordination among member states and key union of the institution. This is the reason also why we have asked in the questionnaire, and Amalia Orsina also recommend in the last emails to focus also to devote part of our workshop to proposal for legislative reforms. At the same time, bolstering the reflection about the role of non-criminal measures and their interplay with criminal ones in compliance with EU general principle, in particular the principle of proportionality and the bis in idem principle, shows to be essential, and still a question that has not really been dealt with properly in order to achieve the most effective protection of youth financial history, first of all at the national level, and generally speaking also at the level of the Union. Thank you very much for your attention.
Thank you so much to Professor Sigurella. Rosaria, thank you so much for so rich presentation where you focus on the main issue, the implementation of the PIF directive, and also in relation to administrative sanctions and the implementation of the regulation. So after we will have the time to also to debate. Now I would like to give the floor to Professor Zimmermann, Professor of Criminal Law in the University of Düsseldorf, about the this relation is about the implementation of Article 3 of the PIF directive in the German legal system. Please, Professor Zimmermann.
Yes, thank you very much for the kind words, Anna. Can you hear me?
Yes.
Can you hear me clearly?
Yes.
Okay, perfect.
Yeah, we can see you.
Yeah, so thanks a lot for the invitation and the possibility to participate in this very interesting workshop. I have prepared some few PowerPoint slides. I will now try to share them with you. Know if that works. Can you see something?
Yes.
Okay. Yeah. Okay, I have 20 minutes of time. Is that right? Then I will just start and jump into the topic. So I will make few remarks on the implementation of Article 3 of the PIF directive in the German criminal law system. And yeah, my agenda is threefold. Can you see the slides moving? Can you see the agenda now? Okay. So first of all, I would like to make a few remarks on the criminal policy background in Germany with regard to the implementation process. Then I will refer to some dogmatic challenges that we were facing in Germany when trying to implement the directive. And if there is some time left at the end, I will show you how the concrete implementation looks like in German criminal law. So I'll start with the criminal policy background, and I will start with some good news. So the directive has been implemented in German criminal law, and it has been so on time. So what you can see here is a screenshot or a copy of the Federal Law Gazette. So that's what the header of the implementation law looks like, and as you can see, it came into force in June 2019, so right on time. But it's been quite a rocky road until the implementation. Why? So with regard to the history before the convention, the 1995 convention had only been implemented, well, you can say half-heartedly. So some maybe some provisions of the convention have not been implemented properly, and the German lawmaker was for different reasons not so happy to implement it. I will show you a few reasons in the next few slides. So, and interesting is that Germany has voted against the directive in the council. It was difficult though to find what the real reasons have been for that, but well, as a matter of fact, Germany was against it, and when it came to implementing the directive, there was a quite intense debate about the best way how to do this. There were actually a lot of participants in this debate. The first, what you can see here is the official draft of the implementation law, and as you can see in the explanatory memorandum, it was basically framed as a problem, as you can see here. That's the first word of the memorandum. It says this directive is a problem that needs to be solved. And well, how could that problem of implementing it, how should it be solved? As I already said, lots of voices contributed to the discussion. Many renowned scholars gave their expertise. These are just two examples of that, and also the Federal Bar Association rendered a very long memorandum on how that should be done best. So why was there so much debate on how to implement the directive? Now I have to make some remarks on the dogmatic challenges. I think the main problem is or was that the traditional German concept of fraud, the German phrase would be Betrug, is very narrow and very specific. And the directive, or the use of the word fraud in the directive, did not really match the German concept of fraud. So what is this German concept of fraud about? We have one provision in our criminal code. This is section 263. StGB is an abbreviation of our criminal code. The traditional crime of fraud has 4 main requirements. The first is there needs to be a deception or deceptive behavior, which must cause an error on the side of the victim, and this error must lead to a damage to the assets, and the perpetrator must act with intent to unlawful enrichment. So these are the 4 main requirements. It may sound easier than it is, because the concept of damage in German criminal law is a very specific one. On the one side, it is very broad because it does not only cover a loss, but also some constellations of mere endangerment. So it does not necessarily mean that you lose assets forever. They may just be endangered, and that in some constellations we consider this already as a damage, which makes it pretty easy for the German lawmaker to implement other provisions that say that attempt must be a crime as well, because in many cases when other criminal law concepts would say this is just a mere attempt, we would already say, well, that's already damage because assets have been endangered. But on the other hand, the concept of assets is rather narrow, specifically because of claims of the state against its citizens is not considered, or in specific cases is not considered to fall in the scope of the element of crime assets. For instance, if the state has a claim against one of its citizens because the citizen has to pay a fine, and for some reason that citizen avoids paying the fine by causing an error, that would not be considered a fraud because the claim to have the fine paid is not part of what we consider an asset. I do not want to go into details. You just please just keep in mind that the German concept of asset is very narrow. So that makes it difficult to implement broader concepts of fraud into German criminal law. We have, because our concept of fraud is so narrow, we have some other criminal provisions. One that is very important as well is a subsidy fraud in the next section, the criminal code, which only requires a deceptive behavior. So in order to fulfill this crime, there's not even a consequence required in terms of damage to assets or a loss of assets. That is also because it is not that clear if subsidies are, or if a state is granting subsidies to some company, if that causes damage to the assets of the state because of the reasons I just mentioned. So we have a specific provision on that. And then German criminal law knows the concept of embezzlement, enshrined in section 266. That this crime requires a breach of duty to manage assets, and it also must lead to a damage to assets. And last but not least, we have the crime of tax evasion, which is regulated in the fiscal code. AO is the abbreviation for our fiscal code, Abgabenordnung, the fiscal code. And this is, we consider this as a specific type of fraud. And in order to commit this crime, you need to misinform the tax authorities and thereby obtain tax advantages. So this basically is a set of crimes that we know and that we have known before the directive. Now, what was a solution for the lawmaker to implement the PIF directive? Within the debate back then, some scholars said, well, it is important to implement it completely, the directive completely, within those 4 crimes I have shown you above. So we may need to alter or expand these crimes. Others said, no, the best way of how to implement it would be to create a complete new law, like a specific criminal code only dealing with the financial interests of the EU being damaged. So what did the lawmaker do? He said, we choose a very clear path. So we do something very clear and specific by, on the one side, partially amending those sections, and on the other hand, creating a new law. but an auxiliary law, as we call it, which means it's a law that stands next to the regular criminal code. And this law is called the EU Financial Protection Strengthening Act, with a very interesting official abbreviation, EU FINSTG. Nobody can, it's hard to pronounce that. And well, even though the lawmaker considered this to be a very clear and precise way, I say it's the opposite is true. I think this two-law solution is very unclear and rather confusing. In fact, nobody who's not an absolute expert on this even knows about this auxiliary law. None of my students have ever heard about the EU FINSTG, and I think there are many prosecutors who haven't heard about this as well. And I have tried to find an official translation of that auxiliary law. There is none, which I think speaks for itself. So no English translation of this. Yeah, so those are the dogmatic challenges, and now I will use the remaining time of showing you what that implementation looks like in the German law system. So on the left side of my slide, you will find the Article 3 you are familiar with. And on this slide, I will talk about paragraph 2, letter A, which deals with non-procurement related expenditure. So non-procurement related expenditure mainly refers to subsidies. And so this provision is implemented by the crime of subsidy fraud. And as you can see in paragraph 8 of the German provision, that one was amended. Subsidy is specifically defined also as a benefit from public funds under the law of the European Union. So that was a change that has been made to make this fit for subsidies granted from EU funds. With regard to number 1, use of false statements is covered by number 1 of paragraph 2 of the German crime, which deals with furnishing an authority with incorrect or incomplete particulars regarding specific facts. Or using false documents. This is covered by number 4 of the German crime, using certificates which were obtained by furnishing incorrect or incomplete particulars. So I think that is pretty well implemented. Number 2, the non-disclosure of information is covered by number 3 of the German provision, which deals with withholding facts relevant to the subsidy. And with regard to number 3 of the of Article 3 of the directive, misapplication of such funds or assets is covered by number 2 of the German section, using an object or cash benefit contrary to a restriction given by the subsidy giver. So I think that letter A is pretty implemented. implemented. The next slide deals with letter B, procurement-related expenditure. Since procurement-related expenditure in most of the cases relates to exchangement contracts, this is something that is usually covered by the ordinary crime of fraud. The necessary consequence in Article 3 is the causing a loss to the union's financial interests is mirrored in the German provision, because there you will find the requirement of damaging the assets of another. That matches pretty well. Then the Article 3, letter B, it does not have to, but it has at least to be a crime when committed in order to make an unlawful gain. In order to make an unlawful gain, this matches with the German concept of fraud because the perpetrator must act with the intention of obtaining an unlawful pecuniary benefit. When it comes to actions, the action of the perpetrator, number one would be use or presentation of false, incorrect, incomplete statements or documents. This one is covered by the Act and the German provision of causing or maintaining an error under false pretenses. With regard to number two, non-disclosure of information in violation of specific obligation is also covered by the general fraud provision because you can commit this crime by suppressing true facts if you have a specific duty to tell the other part of the other contracting party those facts, or in case this fails, we have a general provision called commission by omission if you are under a legal duty to give information to another. Up until here, that was pretty easy for the German lawmaker to implement. Very difficult was number three, though, the misapplication of such funds or assets. Why is it difficult? Well, in Germany, this is not considered to be a fraud because fraud means you need to deceive the other one before he gives the money. And now we are dealing with cases where you have been given the money already and just afterwards you use them in a way you're not supposed to use them. This is nothing that we consider to be fraud. We might consider this to be the crime of embezzlement. However, the general provision of embezzlement under German criminal law requires a very a specific caretaker duty, and usually this is not the case in the situations we are talking about in this regard. Therefore, the German lawmaker implemented a new section in this new auxiliary law in the EU Finch, and this crime is called the misapplication of EU funds, trying to mirror exactly what number 3 of Article 3 litera B says. The translation here is not an official one, as I've already said. This is AI generated by myself. Now, with regard to Article 3, litera C, revenue other than revenue arising from VAT-owned resources. So this mainly is about taxes. So the provision in German criminal law dealing with those situations is a tax evasion clause in the fiscal code. With regard to the consequence, it must have an effect of illegal diminution of the resources of the union budget. Well, the result of tax evasion in German criminal law must be understating tax, which fits. By what is the act of the perpetrator? Use, presentation of false, incorrect, incomplete statements or documents is covered by number 1, furnishing the authority with incorrect or incomplete particulars. Or cases of non-disclosure of information, violation of specific obligation is covered by number 2, failing to inform the revenue authority of facts when obliged to do so. Misapplication of legally obtained benefit also is covered by number 2 of the German tax evasion clause. That is not so easy to see at first glance, but within the fiscal code, we have another section stating that if you want to use anything that falls in the scope of this code, you must basically ask the authorities or tell them before. If you fail to do that, you commit a crime covered by paragraph 1, number 2. So this is pretty much covered. So this part of the directive is covered by German fiscal code, but it was important that the fiscal code had to be extended in terms of the definition of tax, which was done by the German lawmaker. However, the term taxes in the German criminal law does not cover all situations which are meant to be covered by literacy of Article 3 of the directive. In specific situations, let's think about fines that companies have to pay because they violated European Union market law, for instance. That does not fall under the scope of tax evasion, neither under the crime of fraud, because that's not considered to be assets, the claim of the state for fines. And as you can see on the right side in the fiscal code, we have specific definitions of taxes, and specific constellations do not fall under this scope. Therefore, to also cover these cases, we have created a specific section in this new law called unlawful reduction of EU revenue. I have tried to find any decisions by courts on that provision. I haven't found any. I don't know why. Probably that is not applied very often. So this is my last slide. Litera D in Article 3, paragraph 2, revenue arising from VAT-own resources. I think it's fair to say that these cases are completely covered by the tax evasion clause of the German fiscal code. Yeah, sorry that I had to rush through that, but I just wanted to give you a brief understanding of how German criminal law looks in this regard, and I thank you very much for your attention.
Thank you so much, Professor Zimmermann, for this so precise presentation about the implementation of Article 3 of the PIF Directive in the German system of law and the issue. Maybe later, would like to ask you if you have some reform proposal also now to better implement the PIF Directive in the German system of law during our debate. Now, we have the, sorry, okay, Professor, I would like to give the floor to Professor Nieto Martin, the implementation of the EU PIF Directive and the regulation of 1995 in Spain. So, Adan, I give you the floor. Thank you so much for your presence here.
Thank you, Anna, and thank you, Rosaria and Amalia. I am very fan for Amalia work, and it's the first time that I collaborate with Amalia. Well, I think in few days, on September 21, it will be the anniversary, 37 years, of the Graceland Maize case, almost 4 decades. This case is, as all we know, the seeds not only of the protection of financial interests, but of the whole discussion on European criminal law. So it is time to ask ourselves a series of questions, of key questions. Has the design for the protection of financial interests been completed? Can we say that there is effective, proportionate, and uniform protection in the member countries? I think a quick reflection is enough to say no. Today, the protection of financial interests is, in many respects, no longer at the forefront of European criminal law. It is no longer the driving force. For example, in terms of administrative cooperation for the investigation and punishment of irregularities, the cooperation that exists between national competition authorities and the Commission, or the cooperation that exists in relation to market abuse with ESMA, exceeds the level of cooperation that exists between the national authorities responsible for the management of financial funds and OLAF. And if we compare the 1985 regulation with the Directive 2019-1 on harmonization, the measure of supervision and cooperation between national authorities in competition matter, the regulation of on protection financial interests seem clearly an old-fashioned text. And this is not only the case in the investigation of irregularity, but also in the use of administrative sanctions. These remain anchored in a type of sanction that in the 90s were called sui generis sanctions. The EU wanted to impose sanctions without attracting attention because it was in this time unclear to what extent it had the power to impose fines. This was the reason for these punitive administrative measures that are in the borders of Engels' doctrine. Contrary to the expectation, the 1995 regulation has not served to create genuine administrative sanctions in this field, similar to those that exist today for market abuse, for example, or those imposed by European Central Bank. But of course, it is not the aspect I wanted to discuss today. The new generation of directive, which includes the draft directive on the fight against corruption, has shown that the level of harmonization is much higher today than it was 10 years ago when the PIF directive was adopted. The Parliament pointed out this fact in the 2023 communication. The PIF directive needs to be reformed to bring it into line with the new level of harmonization. The PIF directive has become obsolete, especially when compared to the draft directive on combating corruption. In fact, in respect to the Spanish criminal law, I believe that the only success of the PIF harmonization process has been the subsidy fraud offense. This offense was the main goal of the harmonization when fraud became part of the political agenda more than 3 decades ago. But beyond this offense, its results have been very poor, at least from the point of view of Spanish criminal law. As follows, I will highlight a number of black spots in the harmonization of financial interests. The first is fraud against the common custom tariff. The second is the manipulation of public actions as a result of agreements between bidders. And in the third place will be a little note about 2 problems. First, the importance of the perpetration, the author paying back the money they defraud in order to punish cases of fraud. And second, the punishment of the Fraudsleges, the Umgehungshandlungen, and the circumvention of the law in order to obtain aids or to avoid a tax. I comment on them briefly. The PIF directive has harmonized VAT fraud and within intra-community VAT. However, is no reference in its preamble to fraud involving the common custom tariff. Custom duties are the only own resource in the strict sense of the term, and therefore, in a surprising way, the Court of Justice has clarified that customs offense, even when they affect the common custom tariff, are not linked to the PIF directive. In the Kolev case, a case of 2018, and therefore after the directive, it has pointed out that member states are free to define custom offense within the general limitation of dissuasive, effective, and proportionate penalties. And the judgment doesn't contain a single reference to the PIF directive. And the autonomy of the custom offense that protected financial interests and the PIF Convention and now the PIF directives is very evident in Spain. Smuggling offenses are completely unrelated to the PIF rules. These offenses were drafted in 1995 when the PIF Convention was approved, and the PIF Convention was totally ignored. The same didn't happen with the Criminal Code, also approved in 1995, and where the PIF Convention has a great importance. Following the adoption of the directive in 1990, directive of 2017, the situation has not changed. Smuggling offenses have continued to be ignored PIF regulation. The criminal conducts that are incriminated have a very different aspect to the provision of the directive, but not only the conduct, also the sanctions and the distinction between administrative sanction and criminal sanction are based on criteria other than those established in the directive. In the case of Spain, almost this is not worrying. Smuggling offenses that protected financial interests carry more severe penalties than those provided for the PIF directive. And the behavior also covers a broad spectrum that the directive. That said, what is the purpose of the directive in terms of tax, in terms of revenue? It is only for cases of VAT fraud, which was already a clear case of tax crime, of tax evasion in all countries. On the other hand, I have the impression that the situation in customer fraud changes from country to country. There are at least two main models. On the one hand, there are countries like Italy and Spain, which maintain smuggling offenses. And on the other hand, there are countries such, I think, Germany, where common custom tariff fraud is a normal case of tax fraud. I don't know if that is exactly, but I will discuss after with Till. A few years ago, in 2013, the Commission presented a proposal for a directive to harmonize smuggling offenses. The project was abandoned just as negotiations on the PIF directive were beginning. It attempted to harmonize administrative and criminal sanctions. The most surprising thing about the text is that it established offenses subject to a strict liability regime. Besides, these were the majority of the sanctions. This implied that the Commission considers that, in some way, the sanction of smuggling raises important, almost systematic differences with PIF crime. Although the European Court of Human Rights, as we know, in the Salabiaco case, considered that strict liability doesn't violate the convention. In Spain, almost in Spain, but I think in other countries, it is absolutely clear that the principle of culpability applies to both criminal and administrative sanctions. In short, with regard to the common custom tariff, there is no harmonization whatsoever. And apparently, there is no clear idea of how to achieve it. The situation is worrying because the Commission itself, in a recent report 2023, admitted that there are many differences between member states on this point. The second black point in harmonization, the second weakness of the PIF directive is fraud in public tenders and bidding processes. From a phenomenological or criminological point of view, fraud takes two forms here. The first is corrupt behavior. This is not limited to bribery, but is bribery too, embellishment and abuse of office, prevaricación, are crimes that are linked up with this type of crime. Once the directive on corruption is approved, this behavior will be strongly harmonized. But the same will be not true on the second form. Agreement between the various bidders in a public tender. The PIF directive contains a regulation that is of little use in this regard. The conduct it seeks to punish coincides with that of subsidy fraud or revenue fraud. The directive establishes a kind of fraud, trufa, or betrug offense in Article 3.3b. But this concept is of little use in punish agreement between bidders. For this reason, most countries have specific criminal offenses. Once again, there are two main models in the EU. On the one hand, there is the German model of Submission as Prachen, where the relevant factor is the submission of a bid as a result of the agreement. It is a crime of danger. And unlike the crime of betrug, trufa, estafa, fraud, it's not necessary to prove the existence of any financial loss. But in this point, Article 3.2b of the directive, Zimmermann said, or Professor Zimmermann said that already, especially requires the existence of financial loss. The other model is that which comes from Napoleonic Penal Code. It is the one we follow in France, Italy, and Spain. The typical conduct is not related to fraud. It involves altering a public tender through violent acts in general, or what it is of interest here, reaching agreements between the different bidders. In Spain, the PIF directive has not achieved in absolute that such conduct will be punished when it affects financial interests. Judges have not attempted to apply the crime of fraud to these cases, nor do they use the crime of price manipulation in public actions. In Spain, agreements in public actions are punished under competition law. And for many reasons, these administrative sanctions are not effective. In long time ago, in 1999, the Commission presented a draft framework decision on this matter. And I remember in Eurodelitos, the project lead for Professor Tiedemann more than 20 years ago, a criminal offenses was also formulated. However, these initiatives had little success. The cases of smuggling and collusion in public tenders highlight one of the major problems with the PIF directive, in my opinion. The very open manner of Article 3 when it comes to describing typical behaviors. All the types of fraud must fit into three conducts that are always the same conducts. And I think the lack of harmonization is a victim of this simplicity of the directing in this point. Although I do not have any more time, I could mention two other very important aspects of the protection of financial interests that PIF directive doesn't address. First, I should be clarified whether obtaining a subsidy or failing to pay a tax for Fraus legis Umgehung in German is a criminal offense. Here, I believe there are also significant differences between countries. In Spain, for example, there is an agreement with the Constitutional Court in the front of this agreement, which states that tax evasion or the illegal obtaining of a subsidy cannot constitute a criminal behavior. And on the contrary, in other countries such as Germany, conduct involving Umgehung can be punished under criminal law in some occasions. The 1995 regulation of protection financial interests address this use of Umgehungs, circumventions conducts in Article 4.3, which provides for a clause or fraud similar to that which exists in Germany in the Subsidies Act, in the Subventionengesetz. Perhaps this precepts, Article 3, interpreted in conjunction with paragraph 264, leads to the conclusion that subvention fraud could be committed through Umgehungshandlungen in Germany. But I repeat, it's not the same in Spain. Well, in the last point is the effect that have the of active withdrawal in the case of fraud. That behavior can be referred to with various names, Tätige Reue in German, or tax regulation in Spain. And the voluntary payment of the defraud amounts has very significant effects on the penalty and the process in all legal system. Similarly, even if it is not voluntary, the repayment of the defraud amount is usually very important in sentencing. In Spain, in cases of tax offenses, it is most common for the case to resolve in this way. If payment is made and agreement is reached with the prosecutor, the process is finished. And that is the normal case in tax fraud and evasion cases in Spain. Payment is the end of the process. Then the directive refers to the recovery of sums in Article 13, but its wording is unclear, and I do not believe it has achieved any harmonization. In Spain, for example, the reimbursement of the amount subject to fraud to the interests of the Union is given the same consideration as in cases of internal fraud. But I am not sure that is the same case in all the countries. Well, I go to the conclusion. Although the PIF directive is relatively recent, it needs to be revised. It doesn't meet its objectives. It has became obsolete. Although I have not mentioned it, I don't want to bore you with very internal issues, but the PIF Convention says 1995 and the system of amounts have always caused many problems on adaptation in the Spanish criminal code. Besides, we have some crimes resulting from the PIF directive, such Article 306, which nobody knows what cover exactly and what conduct is punished. That is the level and the result of the harmonization, in my opinion, is not like in another fields of the harmonization. If we compare the harmonization in mark abuse and the harmonization in PIF, the different level of harmonization in global terms are very different. And thank you very much. I don't know if it was useful that I said. I know that I don't make the homework. They have to do the report of the study. Thank you very much.
Thank you very much, Adanna. No, it was very useful. So your perspective in relation to the criminal system and also the administrative system of law, and all the problem of harmonization and implementation. So I suppose that you can give us some very important indication about policy recommendation from proposal. So I give the floor to Dr. De Lucas of the Office of Spanish EPO, always about the implementation UPIF directive and the regulation spec.
Well, thank you very much. Okay, I know I am not Ignacio De Lucas because he couldn't attend to this workshop. I am a European delegated prosecutor that worked with Mr. De Luca and Juan José Navas. Well, and thank you very much for this, for letting me to share my ideas or what we work in the EPO office and how important is the directive PIF. So if you don't mind, I'm going to, I don't know if you can see my presentation. Can you see it?
Yes, we can see.
Okay. Well, thank you very much. As I told you to the organization, and I will be very brief because I know that we don't have enough time. Well, the first step, I'm going to talk to you about how important the implementation of the directive PIF in our national legislation. But to talk about this implementation, it's very important to know, to be aware about how important is the European Public Prosecutor Office. As you know, the EPO office is the first body in the European Union to investigate crimes against the European Union financial interests and to prosecute the perpetrated within the scope of its competence. This is very important because I would like to highlight this part of my presentation. It's the first body in the European Union. We have another agencies like Europol or Eurojust, but this is the first step in Europe that we have a body to investigate crime, in this case, crime against European financial interests. A body with organic and functional independence, with the power to draw up its own regulations, the capacity to adopt its own initiative with its criminal proceedings, without being subject to order from either the European Union or the member state. This is why is very important the EPO. As you know, this is a frame of my presentation. It's in Spanish, but as you see, in 2018, Spain lost about mostly 5 million of euro for fraud. For this reason, it's very important to know how it works, EPO office. This is your, this slide, you can see a timeline of the EPO, the creation of the European Public Prosecutor Office. Is very important this year, 2017, because as you see, we have the directive and the regulation. And then In 2021, we have the appointment of the different EDP. EDP, as you know, is the European Delegated Prosecutors, and the National Adaptation Legislation and Start Operation. For this reason, in 2021, we started the operation in the EPO office. Well, as you see, we have different members of EPO, but I will try to explain more or less the different regulations or the legal institutional regulation European Public Prosecutor Office. As you see, we have that we have the Council regulation, the rule of procedure, the general guidelines, the organic law 21, and as Mr. Adán Nieto say, the PIF directive of 2017. This is very important because in our criminal code, and also we have the criminal procedure law. About the temporary jurisdiction is also important because sometimes there is a little bit confusion about how important, how start the EPO office committee from the entry into force of the regulation. So since 2017, we could start operation, but the date of start operation was in 1 June 2021. About the territorial jurisdiction, we have different rules, as you see here. In our article 23, we could investigate crime that had been committed in whole or in part in the territory of one or more of the member states. This is section VAT fraud, I will explain then. Had been committed by a national of a member state, provided that a member state has jurisdiction over that type of offense when committed outside its territory, or had been committed outside the territories or referred to in point A by a person subject to the staff regulation of officials of the condition of employment or other servant at the time of the commission of the offense, provided that a member state has jurisdiction over that type offense when committed outside its territory. About the material competence, and this is what I would like to explain, we have the PIF Directive 2017 of the European Parliament of the fight against fraud affecting the Union financial interest through criminal law. We have in Spain, this is a very important law, is the Organic Law 1/2019 that reform our criminal code. It covers the fight against fraud against European Union financial interest through criminal law. This is very important because, as I said at the beginning of my presentation, we have competence to investigate criminal offense, so we have to reform our criminal code. It harmonized the definitions, penalties, and limitation period for criminal offense, exactly. And we have competence to investigate cross-border VAT fraud involving a total damage in excess of, as you see, 10,000 million. This is important because one of the most important investigations that we have in the EPO is the carousels about the VAT fraud. You know that sometimes it was very difficult in each state to investigate this kind of crimes. So for that reason, because it affects different territory of Europe. So for that reason, it was very important to change the law and to allow EPO to investigate VAT fraud, especially when we are talking about cross-border VAT fraud. But also we have competence to investigate other type of fraud affecting the European financial interest, corruption that harm the European financial interest, and also, this is very important, embezzlement of European funds of assets by the public official. Also, money laundered and organized crime and another inextricably linked crime. How was the transposition, into national law. Well, in our criminal code, we have crimes against the treasury of the Union. As I told you, in VAT, the territory of 2 or more member states of the European Public Prosecutor Office and entail at least a total loss of 10,000 million euros. Crime of fraud of suicide and European aid, money laundering offences involving property derived from offences adversely affecting the financial interest of the Union, bribery offence, when they do or are likely to harm the financial interests of the Union, offence of embezzlement of public funds when it harms the financial interest of the Union in any way, smuggling offence when they affect the financial interest of the Union, when for example, when custom debt is generated, offences relating to participation in criminal organization whose main activity is the commission of any of the offences provided for in the preceding paragraph, offences inextricably linked to the vote when they are instrumentally and committed in the offence with the competence of the European Public Prosecutor Office. This is also very important, but because sometimes there are some confusion about this competence, because we have also the possibility to initiate investigation when we have to prove that this crime is linked to another crime competence of the EPO offices. And finally, another criminal act that affects the financial interests of the European Union within the meaning of the PI directive, regulate of their specific legal classification given to the Article 20 paragraph of the regulation. For example, as you see in my presentation, a subsidy fraud that must be classified as scam. Well, you can see here, it's just a little slide, the structure of the EPO office. We have a central level when we have different structure like the European Prosecutor General, the College, Operation, Permanent Room, and European Supervisory Prosecutor. And then, as you see, we have the European Delegated Prosecutor. Well, I will pass this slide. What about the outline of the investigation under the PIF directive? Well, we have also different way, but the most important thing is that the information read to the European Public Prosecutor Office, for example, under the structure, under the scope of the PIF directive, and we have to send, or people, citizen, or anyone can have to fill up a report, a crime. Then we have the phase of the verification. We have to verify is this report of this statement is under our jurisdiction. When we verify this stage of the investigation, we can open an investigation, and in this case, the EDP investigation from the start to finish with the support, of the final investigators, analysts, national police, custom, tax agency, and also it's with the also always supervised by a permanent chamber in Luxembourg. And finally, the case is tried before the National Court, in our case, in Audiencia Nacional in Madrid. You see, this is how doing the individuals report. You can go to our website, report a crime, and this is the different countries, and then it is sent to the Luxembourg. Luxembourg send us via CMS, is our website, and our computer send the crime, and then we can initiate an investigation. About the exercise of competence under the scope of the PIF directive and the Organic Law 2019, we have different ways. The most important is, as I told you, about the EPO crime report, but we can also have the possibility to exercise the competence about the Article 25. In this case, you see the European Public Prosecutor Office shall inform the competent national authority without undue delay of any decision, whether or not to exercise its jurisdiction. But this is the most important thing that I'm going to explain you about the right of revocation and evoke. Sometimes we can evoke a case. What about the evoke a case? Evoke a case means that sometimes the case is under investigation in a court, and we know that this court is investigating the case apparently with competence of under the competence of the EPO. For that reason, we can send some information to this court about the scope of the investigation, the crime, and when we have 5 days to decide if we evoke the case. In case that we think that the case is under the scope of the EPO jurisdiction, we can evoke the case. As you see, we can open the investigation under the principle of legality. We can use different investigative measures available under national criminal procedure law. For example, we can do interrogation. We can interrogation witness. We can search. We can also interrogate a suspect. Well, the same as any judge or prosecutor can do in Spain. And also we have procedural guarantees that everything is under this important principle of legality. That national procedure law and European directive procedure rights and our judicial review. Finally, we have the cross-border investigation under Article 31 with participation of other member states. This is also very important. As I told you, we have the competence under the directive of PIF that we can have we can initiate investigation in much better crossover investigation. So for that reason, as we are a single office, we can use this very important article what we call in general 31, Article 31, that it means that we can set a request to another office, for example, in Germany or in Italy, and we can request to another college to practice a measure under his jurisdiction, and then they send us the result of this measure. This is what I was talking to you about the cross-border investigation, about the Article 51 of our organic law. We have this European delegated prosecutor send the request to another one, and then we have to the result of this investigation. Also, we can use different, we have different collaboration with Europol, OLAF, Eurojust, and national authorities. And the most important that we have also is OLAF. As you see, we have a collaboration agreement. We try to avoid duplication because they will start or they can start an investigation, but we have to calibrate the penal investigation and administrative investigation. But anyway, with the support of the complement with Europol, Eurojust, and our national authority, especially in Policía Nacional and Guardia Civil. Well, I don't have anything more to say. Thank you for your attention. And of course, thank you very much. And I think that it could be very useful for you. Thank you.
Thank you so much for your interesting presentation about also the concrete activity of EPO and the mechanism in order to activate the EPO competence. So now we have the last presentation before the break. I would like to give the floor to Advocate Cappelletti, a lawyer in the Tribunal of Venice. The title is Revisiting the HEP Regulation, Addressing Operational Challenges and Strengthening Defense Rights.
Thank you, Professor Maugeri. I am sincerely grateful for the opportunity to take part in this important discussion hosted by the University of Catania, and I would like to express my warmest thanks to you again, Professor Maugeri, and to Professor Sicurella, to Dr. Sina for the excellent organization, as well as to all the distinguished speakers and partners of the 2024 IT-PIF project. This initiative provides a valuable platform to reflect through a combination of sound legal analysis and practical engagement on the complex framework that governs the protection of the European Union's financial interests and the evolving role of the European Public Prosecutor's Office. Since its operational launch in June 2021, the EPPO, as said before, has rapidly become a pivotal actor in protecting the EU's financial interests. Its mandate to investigate and prosecute cross-border fraud, corruption, and other PIF offences has already produced a remarkable caseload and shown the potential of a supranational prosecutorial body. At the same time, as an ambitious project operating within a fragmented legal landscape, the first years of activity have revealed structural and operational shortcomings, many of which directly impact the fairness and the effectiveness of criminal proceedings, which, if left unresolved, risk undermining both the effectiveness of the office and the legitimacy of its action. And as we know, by the 1st of June 2026, the European Commission must submit its evaluation report on the implementation and impact of the EPPO regulation as required by Article 118, paragraph 1. That report will assess EPPO's effectiveness and efficiency and will be submitted to the European Parliament, the Council, and national parliaments. In this context, today's discussion is especially timely. As a part of this evaluation process, stakeholders, including legal professionals, have been invited to provide input on the practical application of the regulation and on the possible effects of incomplete, delayed, or divergent implementation. It is from this perspective, as a defense lawyer, that I wish to highlight some key operational challenges and offer proposals to strengthen defense rights in EPPO proceedings. The following remarks, presented in a concise form, draw directly on the observations submitted by the Union of the Italian Criminal Chambers based on the legal practice and scientific analysis of its Observatory of the European Law, which I'm honored to chair together with my friend Amedeo Barletta, in its response to the European Commission's call for evidence on the EPPO regulation. And they also reflect several concerns raised by the Council of Bars and Law Society of Europe in its own submission. Both organizations, while fully supporting the EPPO's objectives, stress that the office's long-term success ultimately depends on its capacity to guarantee effective defense rights and equality of arms within a fragmented procedural landscape. Starting from this evaluation framework, the first critical issue concerned defense rights. The EPPO regulation fails to place defense rights at its core. Article 41 and 45 of the regulation refer to the Charter of Fundamental Rights and to the EU directives on procedural safeguards, but leave their concrete application to national law. This renvoi has produced a patchwork of standards. Suspect and accused persons in different member states enjoy different levels of protection depending on the domestic transposition of the EU procedural rights directives. And this reference results in a highly fragmented landscape in which the level of protection afforded to defense right varies depending on the member states where proceedings take place. A revision of the regulation should therefore move towards directly applicable guarantees at EU level so that the basic rights of suspects and accused persons no longer depends on the accident of geography. And this leads naturally to the second point, the access to the case file. One of the most crucial procedural guarantees is the right of timely access to the case file, which is essential for mounting an effective defense. However, this right is interpreted and applied different across member states, depending on the domestic procedural laws. The European Commission has itself acknowledged compliance issues in the implementation of the Directive 2012-13, particularly regarding the letter of rights, the right to be informed on the charges, and the right of access to relevant documents. In the EPPO context, these disparities are magnified, resulting in procedural asymmetries that can decisively affect the outcome of cross-border proceedings. A truly European system requires a common baseline, ensuring that the defense can consult all relevant documents within predictable timeframes, regardless of where the investigation is taking place. And closely connected is the issue of transparency. The PPO internal case management systems adds another layer of complexity. While the CMS is designed to mirror the national file, it is entirely inaccessible to the defense. Key decisions by the permanent chamber on jurisdiction, indictment, or dismissal are often based on material contained in this digital system. And without a guaranteed synchronization between the national file and the CMS, and without defense access to the underlying decisions, transparency and the adversarial principle are seriously compromised. A mechanism to monitor then consistency and to ensure timely updates is urgently needed, together with secure digital access for Defense Counsel to the relevant CMS material. These transparency gaps intersect with another source of uncertainty, the power of the permanent chamber to reallocate cases among national jurisdictions. The PPO regulation allows the permanent chamber to reallocate, merge and split cases to different jurisdictions in the general interest of justice. This vague and undefined criterion opens the door to forum shopping, undermining legal certainty and equality before the law. The risk is especially pronounced given the lack of a uniform procedural code for investigations at EU level and the variations in substantive law implementing the PAF directive. This discretionary power has already drawn criticism from the European Court of Human Rights in cases where prosecutorial decisions lacked transparent criteria. Clarifying then the criteria for such relocation and limiting discretion would reinforce predictability and protect equality before the law. The problem becomes even more serious if we consider that these decisions are taken without the genuine right of the defense to be heard in advance. Despite the potential impact of the permanent chamber's decision, especially in choosing the forum or applying simplified prosecution procedure, the regulation does not provide for any right of the defense to intervene before these decisions are taken. This silence is problematic, especially when the suspect is already aware of the investigation and could contribute meaningfully to the chamber's deliberation. The lack of procedural participation weakens the principle of equality of arms and may also negatively affect victims, which may face different rights and remedies depending on the forum chosen. Providing a formal opportunity for the defense to be heard would strengthen the principle of equality of arms and enhance the legitimacy of a PPO decision. Added to this, there is the issue of a limited judicial review and access to Court of Justice of the European Union. The regulation does not allow individuals to bring a direct action before the Court of Justice to challenge the EPPO's jurisdiction or competence. Instead, it relies on national courts to refer for a preliminary ruling, leaving the defense dependent on the initiative of domestic judges. In addition, Article 25, paragraph 6 of the regulation allows national authorities to resolve conflicts of jurisdiction between national and European prosecutors without clarifying whether such decisions are subject to review by the Court of Justice. This ambiguity significantly weakens supranational oversight. And to reinforce judicial accountability, the regulation should make clear that questions of competence can be brought under EU judicial review, either through direct actions or through a mandatory reference mechanism. This uncertainty is compounded by regulations' vague rules on expanded EPPO competence, creating further scope for overly broad interpretation of its mandate. The regulation allows, in fact, EPPO to extend its material competence to offences that are inextricably linked to EU financial crimes and to others with repercussions at EU level. These criteria are ill-defined and subject to interpretation, inviting prosecutorial overreach. Recital 54's reference to the case law on the nebis in idem does not provide sufficient clarity. These open-ended clauses risk then to circumvent the limits of a PPO's mandate, calling for more precise legislative language in the interest of legal certainty. And these difficulties are mirrored on the side on defense investigations. The regulation does not provide for autonomous mechanism for defense investigation in cross-border settings. And while Article 41 allows the PPO to request investigative acts on behalf of the defense, this provision maintains prosecutorial control and has been interpreted restrictively in national case law. Given the transnational cases often depend on evidence gathered in multiple jurisdictions, a mechanism allowing defense counsel to obtain investigative measures directly, for instance, to collect information or take statements from an informed witness abroad, subject to judicial control, is essential to make equality of arms a reality. and this imbalance is further accentuated by language barriers. Incomplete interpretation or delayed translation of essential documents limit the suspect's ability to understand the charges and to exercise rights fully. Although Directive 2010/64 guarantees interpretation and translation, implementation is uneven and there is no clear rule on which documents must always be translated. Delays and partial translations, especially of key witness statements, financial records, or permanent chambers decisions, make it difficult for the defense to respond timely and to verify the accuracy of the evidence. The regulation should therefore set uniform criteria identifying essential documents to be translated, impose strict time limits, and ensure high-quality interpretation so that the suspect can fully understand the charges and participate effectively in their defense. And even when formal rights are recognized, material obstacles remains. In many EPPO's cases, suspect assets are seized at an early stage. No harmonized EU rules exist on the use of frozen funds to cover legal fees, and the 16 Directive 2026/1919 on legal aid does not cover EPPO proceedings. To ensure real access to justice, the EU must adopt common standards allowing the use of frozen funds under judicial control for defense purposes and extend legal aid coverage to all forms of judicial cooperation involving EPPO. All these elements converge the practical difficulties surrounding Article 31. Article 31 of the regulation, which regulates judicial review of cross-border acts, remains unclear and difficult to apply despite the Court of Justice's first interpretative judgment on the matter. The provision fails to clearly identify the competent court and the procedural safeguards available to the defense. A thorough revision is required then to enhance the enforceability of defense rights and to guarantee effective judicial protection against EPPO measures taken across member states. Finally, one cannot ignore a trend that touches directly on state prerogatives. Despite the regulation's explicit exclusion of national direct tax offences, in practice, EPPO often investigates these crimes when they are functionally linked to VAT or custom fraud. This de facto extension of material competence encroaches upon national sovereignty and violates the principle of legality. To prevent this drift, clear limits must be set to distinguish between offences within EPPO's mandate and those outside its jurisdiction. Coming to an end, all these different aspects converge in a common message. The full success of the EPPO depends not only on its operational efficiency, but above all on its capacity to ensure uniform standards of fundamental rights protection in a transnational context. Only a targeted revision of the regulation can guarantee this balance. EU-funded projects are essential to foster mutual trust, advance legal harmonization, and safeguard defense rights, providing the ground for initiatives such as the 2024 IT-PIF project, which underscore the vital importance of sustained dialogue between justice sectors, judges, prosecutors, lawyers, and the academic community. Only through such the interdisciplinary transnational engagement can we build a coherent, right-based model of European criminal justice, one that protects the Union financial interest while fully upholding the principles of legality equality of arms, and access to justice. Thank you.
Thank you so much, Dr. Cappelletti, for your very interesting presentation, which focused on the right of defense in this kind of proceeding in front of Apple. So it is very important, your proposal, also your concrete proposal, no? That we can add in our reform proposal in order to implement better the equality, the harms, and the right, no? To defense. So this is a fundamental right. So really, thank you so much. So before our we need a coffee. I would like for some minutes to ask our speakers of this first part of our workshop to give some more precise proposal in terms of best practice, policy recommendation, or reform proposal. No, I would like to start with Professor Sigurella, Professor Zimmerman, Professor Nieto Martin. Dr. Cappelletti has already given us some very precise, and we need your presentation in a written way, so we can better take advantage of your work. So please, Rosaria.
Yeah, thank you. But I will be very short because I think that it's interesting to, to listen to national, I would say, reporters, national experts. Anyway, yes, just to, there's 2 points that already have been raised, actually. One is this very linked to some assessment I've made concerning the directive, the Italian implementation of the directive. That is to say that, as I said in my presentation, I think that we do need a coherent approach when implementing directive. The reason why is also what Adan was stressing, because contrary to what happened in other areas, which are much more specific, like market abuse, etc., we really have to recognize that PIF directive, actually involves really a very wide range of offenses, because we deal according to the directive to PIF, so European Union interest, but at the end of the day we are talking about quite very crucial offenses, dealing with generally fraud, but it is not just fraud, because we know in the Italian system, but also in other systems, this concept of fraud in the directive actually is reflected in, I don't know, maybe 5 or even 6 different offenses. So a coherent approach is necessary. And this was not the case in Italy, first of all, but also, in other systems. I don't want to talk about all the questions that will be dealt with, probably concerning, for example, corruption. I remember when I was participating to the Corpus Juris study, there was this big issue, how to actually only cut corruption in the PIF directive only when affecting EU interests, and how, then you can do when dealing, because we know at national level, this is, corruption is not, connected, the reaction, the fight against corruption is not connected to specific, specific offense. So overall approach, I think this is really very needed at all the national, what also I saw in the report. And second, again, as also Adan was stressing at EU level, I think that, but this is something that all the commentaries were stressing at the moment when the directive entered into force, is that the directive somehow was born quite old, old-fashioned, in the sense that there was almost limited to Lisbonization of provision in the PIF directive. Indeed, the provisions in the Treaty of Lisbon would have allowed a much more ambitious I mean, approach, no, concerning, first of all, concerning also the, I mean, the precision of the definition, in order also to help. Probably the negotiation would have been tougher than it was, because it was. And, but, I mean, we, in fact, at the end of the day, we just, I mean, moved to the national level problems of efficiency, effectiveness of the harmonization at the end of the day. So there was the need for political agreement, which which cut the negotiation. Probably we could be more ambitious. And now, the problem is very strong. First of all, because of, the definition of Article 3, as we saw, but then we will be seeing that also with corruption, with money laundering, the problems are even more sensitive, no? Because the definition of money laundering was directly linked to the definition of a directive that was already replaced. And corruption, now we have a proposal for directive which is much more ambitious. I don't know which will be the but this is incredible that looking at the text of the proposal, in the proposal of directive for corruption, anti-corruption, it says that does not automatically change, for example, the definition of corruption in the PIF directive, which is politically speaking understandable because they are afraid about the competence of the EPO, but logically speaking, also in approach, in a coherent, rational, and efficiency driven approach is not coherent. But first of all, so coherence at your level, but first of all, for what in our side, a coherent approach from the national legislature.
Thank you so much. So I give the floor to Professor Zimmermann.
Thank you. I will make it short. First of all, Rosaria, I pretty much agree with everything you said, and I want to pick up the term coherence. The one thing I would like to highlight from the national German perspective is that from a lawmaker's point of view, I think the Germans chose the worst way of how you could implement the directive by having a completely fractured national criminal law, that we have like 3 or 4 different criminal laws covering just parts of Article 3 of the directive. That makes things so intransparent and so difficult to use for everyone who's trying to use German criminal law, that prosecutors, defense lawyers, scholars. That is something that should be avoided at all costs. You can argue whether or not you make a complete new separate law just covering the directive. That's a German approach to international criminal law, for instance, or you can try to put everything in your regular criminal code. But the fractured solution is a non-solution. So I would strongly advise to not copy the German way. That's all I want to say for now. Thank you.
Thank you so much. Adam, please.
Yeah, that is very interesting, the polemic that we have in Germany, if we separate the regulation. And I think when we try to harmonize crimes like Truffa, like Betrug, the text in the directive could be the same. But the historical interpretation, the case law of the state, it's so different that it's impossible to harmonize it. And that happens with corruption, embellishment, that are crimes that the words are very similar in each country. The words of the Truffa are similar in Germany, in Spain, are very similar. But the case law behind these words are very, very different. So try to harmonize these crimes is very difficult. It's very difficult. We can thought it's done. We have the same taste, but it's not done because the difference are very huge. The polemic or the discussion in Germany about Unterlassung, omission, and Betrug is very different than the discussion in Spain or in Italy. To interpret the Subvention Betrug, you need to know all the discussion that is behind in Germany, the work of the Professor Tiedemann, the links between Subventionsgesetz and Subvention Betrug. That is a word. Each country is a word. And then it is difficult to harmonize. So the idea of separate the harmonization in a specific law could be a good idea in order to preserve the coherence. But all we know that we have a Betrug, that is our national Truffa, but we have another system with a specific law that is the European criminal law. It's the same in Volksstrafrecht. No? The Volksstrafrecht have another rules of interpretation, another context to include the precepts in the criminal code. Is difficult, but there are two different systems with two different logic. So I think I don't know this polemic in Germany, but I think it's a good could be a good idea, or almost we have to discuss a bit about this technique to implement it, to separate, that is clear, European criminal law with its own principles, and for the symbolic of the criminal legislation in the hands of the European Union is important to say to the operators that is European law, which owns fundamental rights, which owns principle, with the Court of Justice at the end of the way that you must to question through a judicial question if you have doubts. It is strange that a court in Spain use the prejudicial question in order to ask something about Betrug, about Truffa, because for the national judge, of course, he have all the power in order to interpret Truffa or tentative. So this idea separate could be a good idea, I think, in order to create a culture between the member states and the national operators that it is European criminal law, and it's different to the national criminal law. No? I remember this project that we have for 5 years to foster in the European Union the culture of European criminal law with its own principle, etc. No? That could be a good way.
So thank you so much. Dr. Cappelletti, would you like to add something? Or?
No, just to emphasize the importance of the dialogue, as I said before, between all the main actors of the academia and jurisdiction. We have a problem of fragmentation. This is self-evident. And it's up to us to try to do our best as lawyers in the court, prosecutors and judges as well. And the academia is very important to give input to put in place or these recommendations.
Perfect.
Most important is that the European Union and the European Commission can listen to our requests. Anyway, thank you.
Important. This is important. We will try. So thank you so much. I suppose that 15 minutes of pause we need, and so we carry on after about 5 to 12. Okay, 15 minutes pause. Thank you so much. Okay, I suppose that we can start. Okay, so I have the floor for my presentation. Okay, can you see the presentation, the slide?
Yes, we can. Maybe you can try if we can see the change of the slides in order
Can you
to
see?
avoid the...
Can you see the change?
No, we see just the first one.
Wow. Maybe, okay, maybe I try in another way. Now you can see the...
Yes, yes,
Okay.
now yes.
Okay, so we can use this modality. Okay, so I would like to speak about the principle of the administrative punitive power and first of all about the regulation. I would before, in order to introduce this subject, remember that the due legal system has a system of immediate protection of its financial interests, which consists of the power of EU legislator to impose punitive administrative sanction. A distinction is made between centralized penalties and decentralized. The first are fines in the competition sector, which normally are provided for by EU legislation in certain regulations that are applied by EU authorities themselves, even if, although in the field of competition, on the basis of Regulation number 1 of 2003, while maintaining the central role of EU authorities, provides for greater involvement of member states. Sui generis, the decentralized penalty sanction are defined sui generis, how to provide for in some EU regulation must be applied by the competent authorities of the member states. Therefore, I would like to remember only in some word the legal basis for this decentralized sanction, because also in the last years there is, for example, an article of Professor Karmer which has some doubt about the legal basis for this power. I would remember that on the basis of some rules attributing in general terms a competence also of merits to the Court of Justice for the sanction provided for in the regulation adopted by the Council, confirms a power of a sanction of the community. the community authorities before, or the European Union authorities, or the European legislator. So, in the opinion of the scholars, community authorities may be recognized as having the power to impose sanctions in all cases where the legislation allows the Council to take all necessary measures or any prepared provision in a certain sector or for the achievement of a certain objective, and also in all areas in which the EU authorities have regulatory powers, of which the power to impose sanctions is a natural and necessary complement, in order to ensure, on the basis of a theological interpretation of the truth, the effective achievement of the objectives underlying the EU powers. This was also recognized by the European Court of Justice in German against Commission case. Okay, this community competence in the field of punitive administrative offences has moreover been recognized by the Court of Justice in Greek Vice judgment. In this sector, it is very important the Council regulation of 1995 on the protection of the community of the European financial interest, which introduced a sort of a general regulation of the European Union punitive power, expressly outshining the fundamental principles of the European Union legal system, already developed by the European Union case law, by the Court of Justice case law, thus rising to the status of a general law or regulatory code of European Union sanction penalties. Although created to be applied to sui generis sanction, it has served as a reference framework for all European Union sanctions, establishing, as specified by the Court of Justice, the general use for controls and sanctions for the purpose of protecting the financial interests of the community before the European Union. In the Gisella case, the Court of Justice affirmed that by adopting regulation, the community legislator laid down a series of general principles and required that, as a general rule, all sectoral legislation comply with those principles. These principles limit the EU punitive power. The regulation set out the principles that delimited the administrative punitive power of the European Union, from the principle of legality to the principle of guilt, the principle of proportionality, and the bis in idem. Today, we can't analyze this principle. The team of Catania would like to, in the conference of February, have a specific part of the conference about the analysis, the reflection about this principle. Today, I would like to introduce this subject, the issue connected with the world of administrative penalties or sanctions in the EU law. I would like to remember that these principles, these are before are developed by the Court of Justice, that since the late 60 years, the Court of Justice has included among the general principles of law the fundamental rights determined with reference to the constitutional tradition common to the member states and the international convention, first of all, the European Convention on Human Rights. Also in the recital 37 of the regulation on competitions and centralized sanction affirmed the importance of the respect of the fundamental rights. The fundamental rights which are now recognized in the Charter of Fundamental Rights of the European Union. In Article 4 and Article 5 of the regulation distinguish between the measure provided for in Article 4, which pursue mere restitution in integrum, remedial restorative measure, and the administrative sanction penalties provided for in Article 5, which in addition to compensation to the restitution of the financial aid, tend to impose a further financial sacrifice, punitive sanctions. In Article 4, the language is important. It affirms that the measure provided for in this article shall not be regarded as penalties. This is expressly recognized, affirmed by the European legislator. So the European legislator does not consider remedial measure to be penalties. In this article is imposed only the withdrawal of the wrongly obtained advantage as a consequence of an irregularity. This was recognized in the Bacau case by the European Court of Justice. Article 5, which demands the respect of the principle of guilty, require intentional irregularities or those caused by negligence, and in this case the penalty are payment of administrative fine, payment of an amount greater than the amount wrongly received or evaded plus interest where appropriate. So an additional supplementary punishment. And there are also a long list, but this list is not exhaustive because in the provision of the letter G refers to other penalties of a purely economic type, which are equivalent in nature and the scope. So the nature could refer to the administrative punitive character, the scope to the intensity of the afflictive character. In any case, the penalties must be dissuasive, effective, and proportionate. Any irregularity, even if culpable, subject to the sanction of Article 5, should be subjected to the compensatory or restorative measure provided for in Article 4. The case law of the court, which is the nature of this measure, the European legislator gives this clear indication, but which is the nature about the measure, the sanction, the penalties of Article, which are included in Article 5, and in general for the administrative sanctions, the centralized and the decentralized. In relation to the centralized, the competition sector, the case law of the Court of Justice and the prevailing legal doctrine affirm their non-criminal nature in stricto sensu for the following reason. The European regulation expressly provided for the non-criminal nature, fines are imposed by the European Commission, they can't be converted into prison sentence, the non-disgraceful nature of such penalties, they don't not apply only to natural person, and the enforcement is governed by the civil procedural law. The same for the decentralized penalties. Also, in the opinion of these penalties are defined by the Commission Legal Service as administrative penalties. They cannot be considered criminal in view of the argument already put forward in relation to centralized penalties, but also for non manieristico criterio. In some legal systems are typical and formal, the criminal sanction, penalties sui generis such as those considered that cannot be considered criminal, and so on. And they are connected with the exercise of a sort of administrative function. But in the right of the European Union, of the Ingle criteria, of the European Court of Human Rights, can we exclude that they are included in the concept of criminal matter? As specified by the Court of Justice, community sanctions are intended to punish unlawful conduct and to prevent its repetition, and therefore have a punitive nature and a preventive purpose, going beyond the mere reimbursement of unduly paid sums, even in the best sense, as observed by the advocate Jacobs, of the stigmatizing character associated with the criminal sanction in strict sensu. Also, advocate Six Hassel affirms this, that there is not this social disapproval, this stigmatizing disapproval. So this means that the extension of the criminal law safeguards to these administrative penalties, as affirmed also in many cases of the European Court of Human Rights, for example, Grant Stevens, this case law of the European Court of Human Rights, although based on individual cases, has contributed to the redefinition of the legal status of administrative sanction. And this was recognized also by the European Court of Justice. I can remember, as repeatedly stated by Advocate General Colomer, although administrative penalties are not as severe as penalties in criminal law, the same general principles are applied in both systems. It is as affirmed by case law of the court. But what is different is the rigor with which the principles are applied. This is recognized. The scholars speak about a modulation of safeguards, the idea of the graduability of a conventional safeguards, for example, in Drusilla case. The criteria to divide criminal and administrative penalties, depending on whether the applicable penalty regime might result in consequences that are more or less likely to stigmatize the perpetrator of the offense. In this, the European Court of Human Rights has emphasized in the last year the importance, in order to distinguish the importance of the significance of the set of interests subject to protection, but also it is important the severity of the penalty, as affirmed in Grant Stevens. It is important not so much a question of when is not so much a question of defining the nature of the criminal aspect, but rather the exact scope of a criminal safeguard, the extension of criminal safeguard, and also the impact of the sanction on the right of the individual. This development also seems to have been influenced by the increasing high level of administrative fines and the particularly afflictive and disqualifying nature of other sanctions imposed by independent administrative authorities. So was power to impose sanction is now subject to increasing scrutiny, as clearly demonstrated by the Menarini case, a subsequent case law. So, regulation is a very important code of the European administrative punitive power, but however, the most recent doctrine observes that there are many examples of a regulatory text on sanction which not only exceed the list of punitive types, this is allowed also by the regulation, but above all, fall outside the scope of the safeguards originally provided for by the aforementioned general use of on the decentralized sanction. This is due, in the opinion of scholars, to the phenomenon of a decentralization of a supranational punitive power in favor of administrative authorities, independent administrative authorities characterized by neutrality and technicality. In any case, I would like to stress the importance of the administrative European administrative penalties, or this system, or also of administrative sanction, in order to apply the principle of extrema ratio or criminal intervention combined with the principle of community subsidiarity. The importance that is in the end it is important in order to apply these two principles, the extrema ratio of criminal intervention is also an expression of the principle of proportionality, which is now recognized also expressly in the treaty in Article 5, paragraph 4, also the Treaty of the European Union. In this perspective, we can say today that the proportionality combined with the principle of a community subsidiarity has been elevated to a guiding criterion for the exercise of the EU competence. This means that